Hello, and welcome to another video about the Economic Crime and Corporate Transparency Act. In this video, we explore the changes the Act will be introducing to the limited partnerships regime in England. The Act aims at implementing reforms to prevent the misuse of limited partnerships while modernising the law governing them. It does this by seeking to improve transparency relating to such entities and the integrity of information held on them at Companies House. Many of the reforms in the Act were first suggested by the government in a consultation which launched and closed in 2018. The consultation was prompted in response to a significant increase in registrations of Scottish limited partnerships and allegations that these entities in particular were being used for illicit purposes. The Act will make various changes to limited partnership law. A number of these changes relate to information that must be supplied to the Registrar of Companies about the partners of a limited partnership and the nature of their business. Requirements to supply such information are typically in the form of obligations imposed on a limited partnership's general partner, which will be the relevant party that typically controls and operates such entities. These changes in large part replicate with modifications existing company law. Changes the Act will introduce include obligations on limited partnerships to provide greater information about their partners on their registration with Companies House, e.g. information such as a partner's name, nationality, date of birth, or where it is a body corporate, their name, registered or principal office, legal form, etc. Obligations on limited partnerships to maintain their registered office at an appropriate address and to have a registered email address. Here, one impact of this change is to provide that any limited partnership registered in England will, following such registration, always need to maintain a registered address in England. Provisions restricting a limited partnership's general partner from continuing in that role when they are disqualified, including in circumstances where that general partner is subject to sanctions. A new obligation on limited partnerships to supply the registrar with information about changes to the partnership, such as changes in partners or changes in the information previously supplied about a partner to the registrar. A new obligation on limited partnerships to supply an annual confirmation statement to the registrar, reporting that all information required to be delivered to the registrar that year has been delivered or is being delivered with that statement. A power for HMRC to require limited partnerships in certain circumstances to produce accounts and make available to it certain accounting information. Provisions to cater for how a limited partnership is to be wound up, depending on whether there are any general partners left at the moment the partnership dissolves. And a mechanism for the registrar to remove from their public records details of limited partnerships they reasonably believe to be dissolved, together with mechanisms to revive partnerships that transpire not to have been dissolved. Here, the proposed introduction of powers to revive a limited partnership are to a large extent intended to mirror the process for restoring a dissolved company under the Companies Act 2006. Further, more detailed information on such changes can be found in materials within our section on economic crime and corporate transparency within the Practical Guidance Corporate section of Lexis Plus. We hope you found the information to be of interest.